you can be seated. Thank you, everyone. Just waiting on two jurors, Ms. Tinker and Mr. Larson. They on? On and working? You want to turn the power on? Officer, any chance you saw Ms. Tinker out there? Thank you. Thank you, Officer. All right, we are back on record. Parties are present. The jury is present as well. The evidence, as I said, was done, so we're time for some jury instructions before closing argument. I've updated all of your books with the new set of instructions. If you turn to those middle tabs, you can follow along with me, and we will go through the instructions. There's one instruction that is set off to the side. It's just because it was an instruction I missed. That'll just be the last instruction once we get there. So the first instruction, if you're looking in your book, you should be looking for B1 in the middle. At the top, it says jury instruction B1. Everyone ready? All right. The evidence has now been presented to you. I will now instruct you on the law to be applied to this case. The fundamental obligation of jurors in a criminal trial is to apply the presumption of innocence and the burden of proof beyond a reasonable doubt. A defendant, although accused of a crime, begins the trial with a clean slate, with no evidence favoring conviction. The presumption of innocence means that you must presume the defendant is innocent of the crime charged. The presumption of innocence alone is sufficient for you to find a defendant not guilty. To overcome the presumption of innocence, the prosecution must prove every element of the crime charged beyond a reasonable doubt. This requirement that the prosecution must prove the defendant's guilt beyond a reasonable doubt is called the burden of proof. The prosecution always has the burden of proving the defendant guilty beyond a reasonable doubt. This burden never shifts throughout the trial. The defendant is not required to prove his or her innocence or to produce any evidence at all. Although a defendant is never required to produce any evidence, he or she may rely on evidence brought out through any witness, regardless of which party called the witness. A defendant has an absolute right not to testify. You must not draw any conclusion against the defendant if he or she does not testify. What is a reasonable doubt? It is a doubt in your mind about the defendant's guilt that arises from the evidence presented or from a lack of evidence. A reasonable doubt is based on reason and common sense. A defendant must never be found guilty based on mere suspicion, speculation, or guesswork. What is proof beyond a reasonable doubt? It is the highest level of proof in our legal system. It is not enough that you believe a defendant is probably or likely guilty, or even that the evidence shows a strong probability of guilt. The law requires more. Proof beyond a reasonable doubt is proof that overcomes any reasonable doubt about the defendant's guilt. The prosecution is not required to prove guilt beyond all possible doubt, for it is rarely possible to prove anything to an absolute certainty. If, after careful and impartial consideration of the evidence of the law, you do not have a reasonable doubt, then you must find the defendant guilty. If, on the other hand, you think the prosecution did not prove every element of the offense charged beyond a reasonable doubt, then you must find the defendant not guilty. Daniel Buckingham, the defendant in this case, has been charged with the crime of sexual assault in the first degree. To prove that Mr. Buckingham committed this crime, the state must prove beyond a reasonable doubt each of the following elements. 1. Mr. Buckingham knowingly engaged in sexual penetration with another person. 2, the sexual penetration occurred without the consent of the other person. And 3, Mr. Buckingham recklessly disregarded the other person's lack of consent. A person acts knowingly with respect to conduct or to a circumstance described by a provision of law defining an offense when the person is aware that the conduct is of that nature or that the circumstance exists. When knowledge of the existence of a particular fact is an element of the offense, that knowledge is established if a person is aware of a substantial probability of its existence unless the person actually believes it does not exist. Sexual penetration means A, genital intercourse, cunnilingus, fellatio, anal intercourse, or an intrusion, however slight, of any object or any part of a person's body into the genital or anal opening of another person's body. Each party to any of the acts described in this subparagraph is considered to be engaged in sexual penetration. B, sexual penetration does not include acts performed for the purpose of administering a recognized and lawful form of treatment that is reasonably adapted to promoting the physical health of the person being treated, or that are necessary part of a search of a person committed to the custody of the Department of Corrections or the Department of Health and Social Services. A person acts recklessly with respect to a result or a circumstance described by a provision of law defining an offense when the person is aware of and consciously disregards a substantial and unjustifiable risk that the result will occur or that the circumstance exists. The risk must be of such a nature and degree that disregard of it constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. Without consent means, 1, that a person with or without resisting is coerced by the use of force against a person or property, or by express or implied threat of death, imminent physical injury, or kidnapping to be inflicted on anyone, or 2, that the person is incapacitated as a result of an act of the defendant. Incapacitated means temporarily incapable of apprising the nature of one's own conduct or physically unable to express unwillingness to act. Force means any bodily impact, restraint, or confinement, or the threat of imminent bodily impact, restraint, or confinement. Physical injury means a physical pain or an impairment of physical condition. If you find that the state has proved each element of this offense beyond a reasonable doubt, then you must find the defendant guilty. If, however, you find that the state has not proved each element of this offense beyond a reasonable doubt, then you must find the defendant not guilty. To return a verdict of guilty or not guilty, each of you must agree with that verdict. You have heard evidence the defendant may have engaged in conduct other than the conduct for which he is on trial. Specifically, you heard that Mr. Buckingham may have engaged in conduct involving touching J.P. and or K.E., and that Mr. Buckingham may have engaged in conduct involving standing outside the park's residence looking through a window. If you find that Mr. Buckingham engaged in this other conduct, then you may only consider this evidence for the purpose of deciding whether you believe it shows TP's state of mind at the time of the alleged offense. You may consider this evidence for that purpose only. In doing so, you should weigh it in the same way as you do all of the other evidence in this case, and only give it the weight that you believe it deserves for that limited purpose. If you find this evidence has no weight, then you should disregard it entirely. Do not use this evidence for any other purpose, or even talk about it for other purposes in your deliberations. It would be improper and unfair for you to do so. Absent circumstances which do not apply to the present matter, the age at which a person can consent to a sexual relationship or the age of consent in the state of Alaska is 16 years old. A sexual relationship with someone younger than the age of consent would implicate the crime of sexual abuse of a minor. The charge of sexual abuse of a minor is not a charge for your consideration in this case. An expert witness is a witness who has scientific, technical, or other specialized knowledge or experience. An expert witness may express an opinion in addition to testifying about factual matters. Determining whether you believe an expert witness and the weight to give their opinions, you should consider their knowledge and qualifications, the reasons given for their opinion, the information on which they are based, the information on which they base their opinion, the factors given you for evaluating their testimony of any other witness. You are not required to accept an expert's opinion, but should give it the weight, if any, to which you find it entitled. As with other witnesses, you may believe all, part, or none of the testimony of an expert witness. Mr. Buckingham has an absolute constitutional right not to testify. Do not consider the fact that he did not testify in any way. Do not speculate about why he did not testify. Do not even discuss it in your deliberations. The state must prove Mr. Buckingham guilty beyond a reasonable doubt. Mr. Buckingham does not have to prove that he is innocent. At the close of trial, counsel may argue the case to you. Their arguments of counsel, based upon study and thought, may be, and usually are, distinctly helpful. However, it should be remembered that arguments of counsel are not evidence and cannot be considered as such. It is your duty to give careful attention to the arguments of counsel if they are based upon the evidence and upon the law as given to you by me in these instructions. But arguments of counsel, if they depart from the facts of the law, should be disregarded. Counsel, although acting in good faith, may be mistaken in their recollection of the evidence given during the trial. You are the ones to determine what evidence was given in this case, as well as what conclusions of fact should be drawn therefrom. The prosecution and the defense have agreed or stipulated to the following facts. The admission of Defense Exhibit A, which is GCI phone records indicating all phone contacts, text and call, between the phone number belonging to Daniel Buckingham and the phone number belonging to Tory Parks between 9/1/18 and 6/30/19. Column A is the date and time of the communication. Column B indicates whether a voice call was connected or not. Column C indicates the length of time a voice call lasted. Column D is the originating phone number. Column E is the receiving phone number. Column L indicates whether the communication was a phone call or a text message. Column F is blank. Column G, H, I, J, K, M, and N include information regarding cell towers, location areas, common language location identifier, and other data associated with the device and equipment used to facilitate the communication. These columns do not provide relevant information. Both parties accept these facts as true. Because there is no dispute about these facts, you must also accept them as true. This time I'm going to turn it over to the parties for closing argument.
Groomed, lied to, manipulated, coerced, raped, broken. That will forever be the Tory Park story because of Daniel Truth Buckingham. The story of a girl who went from a young, happy, vibrant teenager to sitting in her closet all day, not going outside. The defendant started this story on a lie. A 27-year-old man walked up to a group of little girls, two 10 or 11-year-olds and a 16-year-old, and pretended to be a child so they would let their guard down. He talked like a child in front of their parents because he knew that no parent would let him hang out with their children at their house or in his home if they knew how old he was. The only time he didn't talk like a kid was to keep other adults away from Tori, Kate, and Jaslyn. Everything he did was to gain the trust of these little girls. He brought Tori her favorite fruits and sodas. He told Tori how much he liked her smile. He talked about God's love and the Bible. Once he wasn't a stranger, he found a way to go home with the Parks girls. He went to their house. He made an excuse to come inside to use the bathroom. And once he did that, he went to Tori's room. Instead of leaving, he went into Tori's room. When he was asked to leave, he didn't go right away. Had to be asked and told, and after 5 minutes, he finally left. At some point, the Parks parents found out how old he was and said he couldn't come back. And instead of respecting that reasonable request that a 27-year-old man not come into their home and go into their 16-year-old daughter's bedroom, he came back to their house, looked through their windows, looked in Tori's window, and Tori knew about this. He would go to their house when their parents weren't home to help with homework. The defendant convinced Tori, Kate, and Jaslyn to go to his house, where he would be totally alone with them. Once they were inside, he locked the door with a lock that only he could open. He slapped Jaslyn and Kate on their butts in front of Tori. He showed videos of people burning in hell and told them they too could perish and go to hell. He made them hide when his brother came over. When the only other adult that came to his house came over, he made them hide. He told them to hide so his brother wouldn't know that he had little girls in his house alone. When the girls wanted to leave, he only let them leave when they said that their parents were calling, or they threatened to call their parents. After that, he borrowed movies from Tori, and Tori wanted them back. But she didn't want to go alone, so she asked Kate to go with her. So Tori and Kate went back, and at first, the defendant wouldn't let Kate inside, and then Tori let Kate in the house. The defendant then told Tori that her movies were in his bedroom in a backpack. Tori went to get her movies. The defendant followed her. Once they were in his room and they left Kate in the other room, he grabbed her. He held her. He forced her pants and underwear off. He put her on the bed. He told him to stop, but he didn't. He forced his penis into her vagina while she looked away, went into shock, and still asked him to stop, even while she was going into shock. Daniel Buckingham held Tori Parks down and raped her. 16-year-old Tori Parks was raped and impregnated with a baby she didn't want. And even after that, Tori and the 11-year-old girl that was waiting in the other room, scared but couldn't leave because Daniel had to open the door for them, they still weren't allowed to leave. Tori made a fake phone call and said that her dad was waiting on them. Tori told him that she had a tracker in her phone. And then he got scared and let them out. After she was raped, the defendant continued to contact Tori, continued to text her, continued to call her, and only stopped when Tori had her mom threaten to call the police.
Objection, Judge. That's not facts and evidence.
Sustained.
Tori told her mom, tell Daniel to stop calling her, stop texting her. The defendant groomed, lied to, coerced, raped, and mentally broke Tori Parks. And Tori has said the same thing, the same story, reported the same event ever since she told her mother after this happened. The defendant in this case is charged with 1 count of sexual assault in the first degree. And to prove that Mr. Buckingham committed that crime, I must prove beyond a reasonable doubt that Mr. Buckingham knowingly engaged in sexual penetration with another person, the sexual penetration occurred without the consent of the other person, and that Mr. Buckingham recklessly disregarded the other person's lack of consent. Now, you know that first element, that the defendant knowingly engaged in sexual penetration with another person, you know that that's been met. You saw a lab report showing that he's the father of Tori Parks' baby. Mr. Hangy told you in his opening that they had a baby together. You know that sexual penetration occurred. The question that you have to determine is whether that sexual penetration occurred without the consent of the other person and whether the defendant recklessly disregarded the other person's lack of consent, and that other person is Tory Parks. When you're considering that, look at the evidence. Look how the defendant used gifts, money, compliments, and other things to gain the trust and friendship of these little girls and Tory Parks. Consider how he changed his voice to sound like a child, even though he was a 27-year-old man. Consider the lock on his door that kept those girls in there even if they wanted to leave until Daniel let them out. Consider the coercive effect that would have on Tory Parks, 16-year-old girl trapped in his house. Consider how he talked about God's love in the Bible, and then once they were in his house and they couldn't leave, he showed them videos of people burning in hell. The defendant was trying to coerce these girls, and specifically Tory Parks, when he took these actions. He was trying to coerce them into doing what they wanted, and he was trying to make them scared. Not every single detail you heard from each witness was exactly the same. You heard from two girls, Kate and Jaslyn, that were 10 or 11 years old when these incidents occurred, which was over 3 years ago. A sexual assault that occurred over 3 years ago, and the witnesses that testified were two 11-year-old girls and a 16-year-old girl. Kate especially had a hard time remembering what happened when. You didn't get a specific timeline. No one knew the exact date that this happened. But none of that changes what you were told. None of that changes Tory's story. None of that changes the corroborative testimony, the testimony that supported Tory's story that you heard from Kate and Jaslyn. If you have a question about any of that testimony, you should ask to hear it again. Anything you heard in this testimony, you can listen to again. Listen to the witnesses' comments. Listen to their statements and their testimony that they made to you. Listen to Tory, a girl who had told you she had never had sex before, tell you that her lower inside stomach was hurting afterwards because she didn't even know what had happened. She didn't even know what was happening to her. She thought that her lower inside stomach was hurting. Listen to her tell you she didn't know she was pregnant. She told you that he held me, put me on the bed, and made me do stuff I didn't want to do. Listen to that testimony. Tory told you that he held her down with his hands, that she was in shock and she couldn't move, that she was scared, and that she was still scared when she testified yesterday. She was still scared. She covered her eyes. She didn't want to look at the defendant, and yet she still pointed at him multiple times and said his name. Tory told you she didn't want to do it, and that she told him to stop multiple times, and that he didn't. You heard from Jaslyn and Kate, and they told you everything that happened when they went, and about the video of people burning in hell that they were shown. You saw Jaslyn cry on the stand as she told you about how the defendant smacked her on the butt in front of Tory.
Objection, Judge. That's impermissible use of the 4.
Tory's approach.
You heard Jaslyn on the stand crying and telling you about how the defendant smacked her on the butt in front of Tori. You heard from Officer Ulak, former Officer Ulak, about how this was a delayed report and about the actions that he took, even though this report happened months afterwards. And when he was asked about whether there was evidence, he said there was evidence. He said the evidence was the DNA that he collected. It was the testimony from the girls that went to the Child Advocacy Center and were recorded in an interview telling their story, telling people what happened. You heard from Amy. You heard from Amy about how Tori's life has been affected, how her life has changed from this incident. And you heard that she got the same report as soon as she found out that Tori was pregnant, when Tori didn't even know she was pregnant because she didn't know what was happening to her. She got the same report that Tori told you yesterday. The evidence presented to you in this case proves every single element beyond a reasonable doubt. These young girls got up and they told you their truths. They told you their trauma. Don't silence their voices. Find the defendant guilty.
Mr. Angie?
Delayed report. No physical evidence of the use of force. No text messages. No corroboration. All of that combined means the only verdict that you can return, Mr. Buckingham is not guilty. Before I get into the facts, I want to mention some of the law that we're going to talk about. During voir dire, I mentioned the presumption of innocence. The judge read you an instruction on that. As Mr. Buckingham sits here, he is still innocent, unless during deliberations you decide otherwise. The judge also talked about the burden of proof. That's in instruction B2 as well. That says the requirement that the prosecution must prove the defendant's guilt beyond a reasonable doubt is called the burden of proof. The prosecution always has the burden of proving the defendant guilty beyond a reasonable doubt. That burden never shifts throughout the trial. The defendant is not required to prove his or her innocence or to produce any evidence at all. State has the duty to prove something here. Instruction B14, the judge told you that Mr. Buckingham doesn't have to testify and that you can't hold that against him. We talked about that in voir dire as well. Proof beyond a reasonable doubt. A reasonable doubt is a doubt in your mind of the defendant's guilt that arises from the evidence presented or from a lack of evidence. A reasonable doubt is based on reason and common sense. The defendant must never be found guilty based on mere speculation, suspicion, or guesswork. Proof beyond a reasonable doubt is the highest level of proof in our legal system. It is not enough that you believe the defendant is probably or likely guilty, or even that the evidence shows a strong probability of guilt. The law requires more. We talked about, in voir dire as well, we talked about what it means without consent. There's a very specific definition. That's in B7, that a person with or without resisting is coerced by the use of force against a person or property, or by express or implied threat of death, imminent physical injury, or kidnapping to be inflicted on anyone. There's a second definition in there. It talks about a person being incapacitated. That doesn't apply here. That's part of the definition, but it's not relevant in this trial. At no point was there any evidence that Tory Parks was incapacitated. Force is B8. Force means any bodily impact, restraint, or confinement, or the threat of imminent bodily impact, restraint, or confinement. And then you got B12 instruction on the age of consent. What that instruction really means is that Tory Parks was old enough to have a sexual relationship. Let's talk about why the state has not proven beyond a reasonable doubt that Mr. Buckingham committed an offense. First, there's no physical evidence of any use of violence. We didn't have any pictures. We don't have any medical records. There's no testimony from a doctor. Sergeant Ulak got up on the stand and said, oh, yeah, she saw a doctor, but you didn't hear from a doctor. He said, oh, yeah, there's probably medical records, but he didn't get the medical records. He didn't include any records in his report. There's no physical evidence demonstrating the use of force. When we talked in voir dire, the first thing people said, evidence they'd like to see, is physical evidence. Now, don't get me wrong. There is a baby. There is no dispute that Mr. Buckingham and Ms. Parks had intercourse. It did not occur the way Ms. Parks said it occurred. There's no physical evidence of use of force. That alone is a reasonable doubt. Now, the state says, well, there's a reason why there's no physical evidence, because she didn't report. Right? She didn't report until August. The delayed report. Tory Parks testified that she was scared to report, that she was afraid. The inference that the state wants you to make is that she's afraid of Mr. Buckingham. But all of the evidence is that Mr. Buckingham and Ms. Parks stopped having communication at some point in the spring. She didn't report in April. She didn't report in May. She didn't report in June. She didn't report in July. In fact, she never reported it. Her mom figured it out. Her mom reported it. And that's when Tory Parks tells for the first time, the story that she was sexually assaulted. That's one delayed report. But who else didn't report anything? Jaslyn Parks didn't report anything. She wasn't there at the time of the sexual assault. She said she was there at Daniel Buckingham's house in December before Christmas. That's not when the sexual assault is alleged to have occurred. She told her story at a CAC interview. They watched a video. Claims Mr. Buckingham touched her on the butt. Tory Parks said it was on her hip. Regardless, Jaslyn Parks doesn't report that to her mom, and she testified to that. Kata Lukic didn't report anything either. First time she told a story was in August of 2019 when she was at a CAC interview. We're going to get into more details about her story, but what's important here is that's the first time that she says anything about anything involving Mr. Buckingham. One delayed report is one thing. 2, 3 delayed reports, that's a reasonable doubt. Corroboration. In voir dire, one of the things that somebody said is that if there's no physical evidence, I want to hear that their stories match up. That's what corroboration means, that the stories are the same. The state's only possible corroborating evidence is Kata Lukic. Jaslyn wasn't there when the incident occurred. Go back and listen to the testimony from the get-go. Tory reports this alleged sexual assault to her mother. She says, Kata Lukic was there. First time she told her mom, she said, in August, she said, Kate was there. Tori went to her CAC interview. She said, Kate was there. When she testified at trial, she said, Kate was there. Kate testified at trial. Kate told you about 2 instances that she was at Daniel Buckingham's house. 2. 1, involving a video and the allegation that Daniel might have touched her butt or her hip. 2, when they went and got movies. When she testified on the stand, she initially said that she didn't go into the room. She didn't go into the bedroom. She stayed in the living room. Go back and listen to her testimony. If you think I'm saying anything incorrectly, go back and listen to it because it's very clear. I went back and talked to her again, and I corrected it. At the CAC interview, an hour before she testified, she said the same thing. She had been at Daniel Buckingham's house twice, and one time the video was played, and the other time she went into the room, saw Daniel with his shirt off, his pants on, Tori's pants on, pulled down a little bit, her underwear on, and her shirt on. She said she pushed Daniel, Tori got up, they left. She wasn't there when a sexual assault occurred. Those aren't the facts that Tori described either. Listen to her testimony again if you want to. She says, my shirt was on, Daniel's shirt was on, he took my pants off, he took my underwear off, and he pulled his pants down. Now, she was iffy on his shirt, but at her CAC interview that we talked about through Officer Ulak, she was very clear, his shirt was on. Those are not the same instances. Furthermore, when Kate was questioned, she said, I wasn't there. Specifically, do you know what sex is? Yes. Did you witness Daniel and Tori having sex? No. It probably happened another time. He wasn't there. That is the only corroborating evidence that the state has, is Kate Alukuk. And she got on the stand and testified. She told at the CAC, she told it when she testified outside the presence of the jury, that there were 2 instances and she wasn't there. The state said in their opening, convinced the girls and the closing, convinced the girls to come to the house, sexually assaulted TP while an 11-year-old girl was scared in the other room of the house. That's simply not what was testified to. That's not what Kate Alukuk said. While I'm on the subject of testimony, one of the things that the state said in their opening is they want you to pay close attention to the details that match. But also keep in mind that this is a very old case and that people's memories go back and forth, right? People forget. They can't have it both ways. They cannot cherry pick the facts that they want you to consider. When we were talking to Kate on the stand, I said, you remember going to the CAC? Yes. Okay, that was in August of 2019, right? Yeah, that's closer in time to when you were last at Daniel Buckingham's house, right? She said, yes. Your memory was probably better then, right? Her testimony on the stand and at the CAC interview was that she was not a witness to a sexual assault. Tori Parks claims she was. That is the only corroborating evidence the state has. It's not there. That is huge reasonable doubt. So what are you left with? You're left with Tori's story. Now, I'm coming back to this because we don't have any text messages. We don't know what was said between Tori and Daniel. We don't have those texts. Those are gone. There's testimony that said that the family tried to get the records, but they were unable to. Police didn't even try. They didn't even look at her phone. They didn't even try and get the records. We don't know what was said, but we have records. $392 pages of communication between Tory Parks and Daniel Buckingham. D16 is the instruction that talks about those records. It tells you what each column means. It tells you how to read them. 392 pages of them. I'm not going to go through one by one. Those records range from September 1st of 2018 through June 30th of 2019. You're going to see in there most communication occurs January and February of 2019, and then it stops in April. There's some communication in November and some communication in December of 2018. 392 pages. 19,000 texts or phone calls between Tory Parks and Daniel Buckingham. 19,000. More than that. Tory Parks and her family got on the stand and testified and painted a picture of Mr. Buckingham bothering and harassing and being creepy. That's not what those records show. January 2nd, you can find this in here. January 2nd at 6:48, after very limited communication in November and December, Tory Parks texts Daniel at 6:48. From that day, they constantly text all day, every day through January 19th. Constantly. You could just flip through the records and look at the dates. There's a small break. Tory texts Daniel on the 25th. They continue talking through the end of the month. Constantly, all day, every day. Text message after text message after text message. It's not one way. Columns are very clear. One column is the sender, the other column is the receiver. Column D is who sent the text message, column E is who received it. They go back and forth. It's not Daniel Buckingham texting nonstop all day, every day. This is a communication. This is why this is really important. Really, really important. Tory Parks said the sexual assault occurred in January. At no point has anyone said otherwise. The indictment says between January 15th and February 15th. Officer Ulak did say, based on his investigation, it could be ranged. Tory Parks never said that it occurred in February. Not once. January. Listen to her testimony. I asked her, January? She said yes. It was positive. After February 1st, including February 1st, 2019, through the end of those records, there are over 8,000 communications between Tory Parks and Daniel Buckingham. 8,000. From the 1st of February through the 22nd, they are speaking daily, constantly, all day. Text message, text message, text message. Ladies and gentlemen, she lied to you. Lied. What did she say? Did you talk to Daniel Buckingham after the sexual assault? No. Positive. Absolutely not. That's a lie. The only evidence that the state has that's reliable is Tory Parks' statement. She cannot be relied upon because she didn't tell you the truth. That's a reasonable doubt. And you know, let's talk about another thing. Defense put in these records. Mr. Beither didn't talk about them at all. The state had an opportunity to call a rebuttal witness, to explain, to put someone on the stand, maybe Tory Parks. Say, hey, what's up with these? They didn't. They were allowed to. That's one of the first instructions you were read, talks about how the trial works. If the defense put on a case, state gets a rebuttal. They didn't call anyone. That's reasonable doubt. The state wants you to focus on things that are in the periphery. This door, this lock, this magical lock that Daniel Buckingham can only open. Why don't we have a picture of that? Why can't we see it? Why didn't the officer go take a picture and show us what this magical lock looks like? Listen to Kate's testimony. Also, by the way, she says, and Mr. Beither referenced this, she says, oh, I showed up and Daniel wasn't going to let me in, and Kate opened the door. Thought nobody could open the door but Daniel.
Objection, Judge. Facts not in evidence.
Overruled.
Doesn't matter. A weird lock doesn't mean somebody committed a sexual assault. Kid's voice. We made this big deal about Daniel Buckingham having a child's voice. Listen to the testimony again. The only people that said that are the Parks. When asked, Kate said, no, he sounds like an adult. State tries to suggest that this is a ploy, trick people to get them to come to his house. All the girls knew how old he was. Every single one of them at the CAC interview said he was 26, 27. There's no testimony that anybody thought he was 16, 17, 18. Again, tertiary. Because you got a kid's voice, that doesn't mean you committed a sexual assault. Now, Tori's behavior, she said she didn't know she was pregnant, yet she remembers when she last had a period. That was in evidence. There's testimony about how she had pain, she's had some issues. It's 3 years later. Everybody who lives out here goes through trauma. We don't know if there was another reason for it. That alone isn't sufficient to prove the state's case beyond a reasonable doubt. I want to talk about the 404, or the two instances that are talked about that you have a special instruction on. It's B11. The window peering. Again, we're not even sure that happened. No police report. Jaslyn says Tori saw it. Tori says Jaslyn saw it. There's no date. There's no details. For all we know, that happened in February when they're still in constant communication. The hip-touching, butt-touching video, to be clear, that occurred in December, if it occurred. Before Christmas. It's irrelevant to the issue of whether a sexual assault occurred in January. What you can consider that for, and this is specifically said in instruction B11, it only goes to, both of these instances, only go to Tory Park's state of mind at the time of the alleged offense. It doesn't go to anything else. Amy Parks came and testified too. But Daniel had been to the house a couple times. She said at one point she realized how old Daniel is, right? Amy Parks' testimony is really short. You can listen to this. Says, I realized how old he is. I told my kids, he You can't come back. Mr. Barther said, is that before the incident? She says, yes, it's before the incident. So when does that put that? Sometime in January. What does Tory Parks do? Goes to Daniel Buckingham's house. Continues to text him daily. These text messages do stop. Whatever relationship they've had ended at some point. There's a pause in the end of February. There are a few text messages in March. In the very end of this, there are some text messages that say it's from his number to his number. Disregard those. There is a communication in April. It's not a phone call, like Amy Parks said. Text between them, and then they cease. Ladies and gentlemen, we've gone over the law and the evidence. I want to read to you again, reasonable doubt, because of how important it is. A reasonable doubt is a doubt in your mind about the defendant's guilt that arises from evidence presented or a lack of evidence. Reasonable doubt is based on reason, common sense. Common sense. A defendant must never be found guilty based on mere suspicion, speculation, or guesswork. Proof beyond a reasonable doubt is the highest level of proof in our legal system. Not enough that you believe a defendant is probably or likely guilty, or even that the evidence shows a strong probability of guilt. The law requires more. Proof beyond a reasonable doubt is proof that overcomes any reasonable doubt about a defendant's guilt. There's reasonable doubt all over this case. The state wants you to not look at the specific facts of the alleged incident. They want you to consider all of these tertiary issues. He sounds like a kid. Showed him the scary video. Maybe he touched a butt. The judge told you you can't consider that for anything towards the guilt of the sexual assault, just towards TP's state of mind. Delayed reporting, not by one person, by 3 people. That's a reasonable doubt. No physical evidence of the use of force. That's a reasonable doubt. No text messages. Just proof that there were 19,000 communications and 8,000 after February 1st. That's a reasonable doubt. And no corroboration. Kata Lukek didn't see a sexual assault. Yet from the get-go, she is the state's witness, their eyewitness. Tory Parks, she saw it, she was there. No, she didn't. That's a reasonable doubt. No explanation from Tory Parks about why she lied to you. Ladies and gentlemen, there is only one verdict that you can return after you do. That's that Daniel Buckingham is not guilty of sexual.
Thank you. Brother?
So Mr. Hange talked a little bit about rebuttal, and that's what this is. And he argued to you that because I didn't talk about this raw data of call logs, that it was somehow an issue for the state's case, that it's somehow reasonable doubt. I didn't talk about them because I know I get to talk about them now, and we're going to talk about them. But I want to clarify a few things before we get to that. No one said Kate was an eyewitness. Corey came and said that Kate was on the couch in the other room when she was raped. Kate said that she was on the couch in the other room. Kate told you that Tori went in to get her DVD player and her movies, that Daniel followed her in, that she heard some thumping, and 10 minutes later they came out. Kate told Mr. Hangy that she never saw them having sex. She was not an eyewitness to the sexual assault. She is a circumstantial witness that corroborates the details of Tori Parks' statements. And Kate did tell you that she had a bad memory, that she struggled with some of the details, and you've been told by the defense now that you can't consider a witness's testimony without considering their age, the age of the event, their memory. That is categorically false. You should take all of that into account when you determine the credibility of a witness. Think about the fact that Kate DeLuca was an 11-year-old girl when all of this was happening. The defense talks about reasonable doubt quite a bit. Let's talk about that. Reasonable doubt is about the quality of the evidence, not the quantity. If Tori Parks was the only witness in this case, and you believed Tori's story, you believed that it proved each element of this charge beyond a reasonable doubt, you could return a guilty verdict on her testimony alone. But she wasn't the only witness. She had other witnesses that corroborated the events surrounding her rape, that corroborated the dynamics, the context of what happened to her. You were told that there's no evidence that Daniel lied or acted like a kid. You heard from multiple witnesses that he was using a kiddie voice. And you heard from some of the girls that they heard him use his real voice in other situations. You heard that. So you did hear evidence that he lied about his age, about who he is, and the way that he acted. And another witness told you that he just sounded like a creep.
Objection, Judge, that was stricken.
I believe that was overruled, Judge.
Overrule that.
Oh.
Did object, and I overruled at that time.
The defense has told you not to believe Tori's story because Kate gave some different details. When Mr. Hangy asked Kate about her story, she specifically told him, "I think that was a different time." That's what she told him. She was mixing up details about different events that happened at Daniel Buckingham's house, and she told you she couldn't remember the timeline. No one knew the exact date. That doesn't change what's happened. That's not reasonable doubt. So let's talk about these records right here. These call logs that you'll take back with you, they show a number, they show Daniel Buckingham's number, they show Tori Parks' number, they show dates, and they show whether it was a text message or a call. They don't provide any evidence on what was said. No evidence of the nature of Tori and Daniel Buckingham's relationship. And they definitely don't tell you what the messages say. But here are some things that you can take away from these. Here's some things you can take away from this raw data that doesn't tell you what the communications were. What you can take away from these is that the last text from Tori Parks' phone to Daniel Buckingham's phone was on April 23rd, 2019, which lines up when Amy Parks told you that she was getting texts and calls and she wanted them to stop, and Amy Parks told the defendant to stop. After that, there were no more. The last call from Tori's phone to Daniel's phone, February 15th, 2019, the exact day that the charging period stops. January 15th to February 15th. That's the last time that a call was ever placed from Tory Park's phone to Daniel Buckingham's phone. But honestly, the date of the assault, the date of the sexual assault, is not an element of this crime. You don't have to decide that it happened on a certain date. It's not an element of the crime. 3,875. That's how many more text messages and phone calls went from Daniel Buckingham's phone to Tory Park's phone than went the other way around. Daniel Buckingham, his phone, called or texted Tory Park's phone almost 4,000 times more than the other way around. You can decide whether that's creepy or harassment or stalking. That's for you to decide, not for Mr. Hange or the defense to decide. 11,940. That's the total number out of over 19,000 text messages and phone calls that went from Daniel Buckingham's phone to Tory Park's phone. He was the one initiating these conversations. His phone was the initiating one. And when you look at these, look at the first text message or call that goes out on each date. Almost every single day, it's from Daniel's phone to Tory's phone first. She responded. She responded a lot. He initiates it. He's texting her. He's calling her. Another thing you can look at these. If you go to February 22nd, 2019, after that date, there are only 2 days where there are communication. One date in March, another date in April. There are no other communications. After, when you look at these, there's an average of hundreds of calls or text messages each day. It goes to nothing except for 2 days after February 22nd, 2019. Shortly after the sexual assault occurred, they stopped texting each other 100 times a day. For what this is worth, it corroborates Tory's story, and that's all it does. You've been asked not to speculate on evidence you didn't hear. Don't speculate about what was in these messages. You don't have to because Tory told you. Tory told you that she got a text message from Daniel after she was raped that said, "Sorry, I see you." You also know that there were text messages, there were communications from Amy Parks asking or telling Daniel Buckingham to stop contacting Tory. That's evidence that was presented to you that you do have. You can't speculate as to what the rest of this is. But you can use these dates, times, and calls to know that this supports Tory's story. Tory Parks has told the same story since she reported this to her mother in 2019. Over 3 years later, with only negative effects to her life, she's still coming in here, speaking truth, and telling her story. She's telling you her story. Listen to her. Find the defendant guilty.
Thank you. All right, final set of instructions, and we will leave you to deliberate. You were accepted as jurors in this case in reliance upon your answers to the questions asked you concerning your qualifications. You are just as much bound by those answers now and until you are finally discharged from further consideration on this case as you were then. Your oath obligates you to conscientiously consider and weigh the evidence and base your verdict on the law and the evidence. When you return to the jury room, which is going to be the courtroom you are currently in, there is no jury room because we can't socially distance you. We will leave the courtroom. You have the entire courtroom to yourself to deliberate. Select a foreperson to preside over your deliberations. Once you have agreed to a verdict on the decision submitted to you, your foreperson should complete, date, and sign the verdict form. The verdict form will be provided to you along with the notepad here that you're going to receive for any questions. Then you should give the note to the bailiff indicating that you have reached a verdict. The bailiff will advise the judge, and the judge in turn will summon the parties. Once all have reassembled, you will be brought into open court to return your verdict. Your foreperson should keep the verdict form and bring it into court at that time. Until it is received in open court, your verdict is a secret, and you should tell no one what it is, including the judge, the in-court clerk, or the bailiff. The attitude and conduct of jurors at the beginning of their deliberations are extremely important. Stating your opinions too strongly or immediately announcing how you intend to vote may interfere with an open discussion about the case. When this is done at the beginning, it may be more difficult to change your position, even if it is shown that it is wrong. Remember that you are not partisans or advocates, but you are judges of facts. As jurors, you have a duty to consult with one another and to deliberate with a view to reaching an agreement, if that can be done without sacrificing your individual judgment. Each juror must decide the case independently, but only after an impartial consideration of the evidence with the other jurors. In the course of deliberations, a juror should not hesitate to re-examine his or her own views and change his or her opinion if convinced it is erroneous. A juror should never surrender an honest belief about the weight or effect of the evidence solely because of the opinion of the other jurors or for the mere purpose of returning a verdict. In your deliberations, do not discuss or consider the subject of possible penalty or punishment. That subject must not in any way affect your verdict. You are not to decide any issue by the simple process of counting the number of witnesses who have testified on the opposing sides. The final test is not the number of witnesses, but whether, considering all the evidence, the state has proved every element of each charge beyond a reasonable doubt. If it becomes necessary during your deliberations to communicate with me, you may send a note by the bailiff signed by your foreperson or one or more members of the jury. You'll be given the notepad here that I talked about, and you'll have the jury form with it. This is the notepad you fill that out on. No member of the jury should ever communicate with me by any means other than a signed writing. The writing should contain the date and time of the communication. I will never communicate with any member of the jury other than in writing or orally here in open court. Judges frequently receive written questions about the case by jurors during their deliberations. Although I cannot always answer those questions, I am free to tell you that if you desire to be informed on any point of law arising in the case, you may write which point of law you wish to be instructed on a piece of paper, hand it to the bailiff, and I will convene the court for consideration of the question. The court has recorded the proceedings in this trial. If you need to rehear the testimony of a particular witness, you may write which witness's testimony you wish to have played back, and we will arrange for you to hear it. No new evidence will be presented. A delay will occur prior to a response to your question or request, since I must first convene the defendant, attorneys, clerk, and myself for consideration of the question. I tell this not to discourage your writing a question, but so that you will understand any delay which might occur. During your deliberations, a bailiff will be appointed to keep you together and prevent any conversations between you and any other persons. The bailiff, once again, will be Madam Clerk here. The bailiff will provide meals. You should have already received your lodging tickets for those from out of town. If you need lodging, that will be available for you. And will make any phone calls for you if necessary. The bailiff cannot answer any questions about this case or provide you with any information, books, or material. The bailiff, as well as all of the persons, is forbidden to communicate in any way or manner with any member of the jury on any subject touching the merits of this case. Bear in mind also that you are never to reveal to any person, not even to the bailiff or to me, how the jury stands numerically or otherwise on the question of guilt or innocence of the accused until authorized by the court. Any violation of any item which I have cautioned you is to be reported to the court. If you have not reached a verdict by the end of court today, you will be allowed to go to your homes. If you are from Bethel, if you are from the village, you go to whatever lodging you have arranged for you. And you are to be back in this courtroom at 8:30 tomorrow morning. You are instructed that it is your duty to discuss the case only in the jury room when all 12 jurors are present. Therefore, when you leave the jury room, you are not to converse with any person on any subject connected with the trial. Similarly, you must not see, read, or overhear any news reports or comments by anyone else about the case. You may only discuss the case and begin deliberating again when all other jurors are together in the jury room tomorrow. I know this instruction says at the end of business today. At the court here, we leave it to you to decide when the end of business is today. I would strongly, we may come get you if it becomes too late and our staff here do need to go home at some point. So we let you go as long as you would like to go, but there will be a cutoff point at some point where you'll just be sent home and come back the next day. With that, we will gather everything in here that doesn't belong in here for your consideration. I'm going to disconnect the Zoom line, the YouTube line right now, and you're going to hear it say